Okay, we are back on the record. Ms. Lindeman, are you still with us?
Yes, sir, I am here.
Okay. Ms. Petrie Ramirez, you may continue.
Thank you, Your Honor, and no further questions.
No further questions? Okay. And Mr. Knight, do you have questions of this witness?
Yes, sir, I do.
Okay, you may inquire.
Ms. Lindeman, is that, did I pronounce your name correctly? Hello, ma'am.
And looks like she's having, can you hear us okay, Ms. Lindeman? I can't hear you. I've lost your mic.
Can you hear me now?
Yes, you lit back up again. Okay, so you're good. Okay, so you can ask the question again, Mr. Knight.
Okay. Good morning, Miss Linderman. Did I say that right?
Yes, that's good.
Okay. You're located in Florida, is that correct?
Yes.
Have you worked as an advocate for 504s and IP in other states?
Yes, I have.
Do the state standards change for each school, for the schools, or are they a standard across the nation?
They can change from state to state.
Okay. So are you a professional in every state's school 504 plan?
No, I am not.
How many states have you actually been an advocate in?
Probably about 18, I think was my last count, about 18.
Was Washington State one of those?
I did have one case in Washington State a few years ago.
Can you say you're fully aware of the Washington State 504 regulations and rules?
No, I am not.
Okay. So, if a parent comes to you that has had their medical and educational decision making removed from them, and that parent asks you to intervene into a school situation, would you do that?
Objection, Your Honor, is speculation.
Overruled. You can answer the question.
So that's in my interpretation, that's a very broad question. So in this situation, I was asked to give my opinion on documents that were presented to me, and questions were asked to me pertaining to those documents. So I was asked for my opinion about the documents and the educational perspective only.
Okay. Did Ms. Voss give you the information that all of her medical rights and medical decision making and educational decision making has been removed from her by the courts?
I'm sorry, there's an objection?
That was not that.
If Ms. Voss wanted a
Whoa, I got a pending objection.
So,
I'm just looking for basis of objection.
yes, I know that. it's irrelevant at this point?
So you need to establish relevance. So I'm gonna sustain at this point, and if you can establish why, if that would be relevant, then,
Can I follow that line of questioning a bit?
but you can develop foundation, and yes, that allows you to do that.
In your practice as an advocate, if you had knowledge of somebody having their educational and medical decisions removed, would you be as willing to help them in a custody issue?
Doesn't make a difference, it wouldn't make a difference to me. I mean, if I'm being asked to look at documents and give my opinion on the documents, I have, doesn't, is the, what the parent, who the parent is, what they've done, or whatever, isn't relevant to looking at a document and giving my opinion, in my perspective, my opinion.
Okay. If a parent is requesting your opinion on a medical issue concerning 504 plans, and they don't have the authority to ask that opinion, would that not be a conflict of interest?
So that's, I can't comment on that. I don't know when a parent has a right to seek out advice from somebody or not. So I don't know how to answer that question.
Okay. Did you ever reach out to Mr. Knight, the father of Hayden and Chloe, and ask for any collateral information concerning a 504 plan? Or an
No, I
IEP?
did not. No, I did not.
Did Ms. Voss suggest that that should happen?
No, she did not.
Did Ms. Voss speak badly of the father and his ability to make medical decisions?
No, we didn't talk about that at all.
Since we are going over the Pioneer School District's 504 and IEP plan, did you, in your evaluations, happen to speak with any of the staff from the Pioneer School District in the state of Washington?
No, I did not.
So it would be safe to say that the school did not provide you with any collateral information as to what was going on with Hayden's 504 or IP plan?
No, they did not.
Would it be safe to say that you only received information from the mother?
Yes.
Do you have full knowledge of the custody case going on at this time that you are a part of?
No, I do not.
Do you feel your opinion should be weighed heavy on this custody battle?
I have no opinion on that. I can't make that determination. I don't know anything about the custody battle.
Do you have a psychology degree or a psychiatry degree?
I do not.
And I would ask the court to strike that, as an objection, because that was asked and answered prior.
It's cross-examination. It's allowed.
So if parents have been involved in school 504 plans for approximately 10 years in multiple school districts and have been a part of all the team, would you assume that they would have enough intelligence to know what is available to them through the school IP program?
No, sir, I would not assume that.
Would you assume that everybody that you speak to as a parent don't know nothing about a 504 plan and IP plan?
No, sir, I would not assume that.
Okay. So let's speak about Chloe for a moment. So her evaluation was elevated by Miss Voss's report that you had spoke about. If Chloe was going to counseling on 4 times a month and having a counselor come to the school for counseling sessions, would that have changed some of your opinion on an IEP 504 plan for her?
So when I look at an IEP is designed to look at what the school is obligated to provide without looking at outside resources. School districts aren't allowed to look at outside resources, outside services that the children is receiving. So when I look at an IEP, I'm only looking at what I believe the district is obligated to provide if she's eligible for the services.
Okay. So if the parent has an outside company or source providing psychiatric or mental health care to the child and incorporating it into the school, wouldn't that suffice as an IP for the school? So because they're getting a higher quality of counseling and not divided amongst the school students?
So you're asking me to judge what kind of therapy the child's receiving, if that's appropriate, and that's not in my purview. And again, it's an outside resource, and that outside resources aren't taken into account when developing an IEP and what the school's responsibility is.
So I could honestly say that you have no idea of any outside sources that are being taken or given to Hayden and Chloe beyond their 504 plan. So you could only talk about your opinion of the school.
So I was not giving my opinion of the school. I was giving my opinion of the documents, and I do not know what outside resources the children are receiving.
If you would have had information concerning the outside resources, would you have had so much concern of the documentation that you had been given?
As it pertains to what the school is supposed to provide, no. Because you look at what the child needs and what the school district's responsibility is to provide that child with services. It's irrelevant what support the child is getting outside of school as far as what services the district is supposed to provide.
Isn't it the parent's choice to decide what services their own child gets and not the school?
It's a team decision when you're developing plans. It's a team decision. The school district has an obligation to provide services, and they have their legal requirements that they have to comply with. So it is not a parent's they don't have complete authority all the time. It's a team decision where they come to an agreement in a meeting what kind of services the student will receive.
So if the team decides to fill out a 504 plan instead of an IP, should they have an advocacy person from another state tell them if they were doing it right?
If the advocate's qualified and has experience, that's the parent's choice.
So through these documentations here that you had was looking at, I would like to refer to 55 that you were just in.
Is that 355?
That's 355, page 31.
Yes, sir.
Did you read that letter?
Yes, sir.
From that letter, do you think that Ms. Voss may have been overly communicating with the school or causing any sort of issues that she should not have been?
I can't comment on that. I'm not familiar with what was going on at the time or that was not what my role was to determine that, so I just don't know.
Ma'am, you're telling us that you can make the advocacy opinions about 504 plans without having full and knowledge of what the whole circumstance is in the case of the child. I believe that your services are very well needed for a lot of our population, but I don't think it's needed for us.
You need to ask a question, not
Okay.
express an opinion.
I'm done, Your Honor.
Okay. Ms. Petrie Ramirez, do you have any follow-up questions?
Yes, Your Honor.
Okay.
When you are looking at 504 plans and that are during your advocacy work, do you look at secondary materials in regards to the state requirements?
What specific types of secondary materials are you referring to?
When you're making recommendations for 504 and IEPs, do you look at state-specific laws about these types of plans?
If I need to, yes, absolutely.
And in this situation, did you review those states' laws?
I did review Washington state laws on several occasions when I first was looking at the documents.
And that'll be all.
I'm sorry?
That will be all, thank you.
Okay. Anything further, Mr. Knight?
No, sir.
Any objections to this witness being excused?
I would ask that, yes, we can excuse the witness, but can we reserve the right to recall her in the
Okay.
future if needed?
Okay. So, Ms. Lindeman, you are excused from today's testimony. However, you're subject to recall in this matter, and that will be worked out directly with you. Okay?
Thank you very much.
Okay. Thank you. Okay. I don't see anybody else in our waiting room. Ms. Petrie Ramirez, how do you wish to proceed?
I do not have any more witnesses scheduled for today. I see that it is 4:08, so I don't know if we want to recall Ms. Voss to continue her testimony.
Let's talk about schedule, okay?
Okay.
So we get a sense of where we are right now. So first of all, I have learned that I have a hearing tomorrow morning, and that hearing's at 9 o'clock. I'm anticipating it's going to be about a half hour. Okay, I'll do it right from here. It's going to be a virtual hearing, which means that the parties will be appearing purely by Zoom. So I have no issues. The parties wish to get set up here while the hearing is going on. Of course, you'll just have to be quiet so you don't interfere with the record. That is the only scheduling issue that I have with tomorrow. I'm not aware of any issues on Friday. Let me double check to see if I have anything on my other dockets. I don't have anything in my session right now. So at this juncture, and things are always subject to change, and I'll always let you know as soon as I find out. I have nothing scheduled for Friday. So, Ms. Petrie Ramirez, are you expecting to, we need to pause for a moment. Something I just thought of is that Ms. Johnson was intending to appear at 9 o'clock tomorrow.
Yes.
So I will need to contact court administration to make sure they let her know that it's 9:30. Okay, but she'll be appearing in the morning. And so you have other witnesses named, Ms. Petrie Ramirez. I don't know who you intend to call, and what is your proposed timing of things? Do you have a sense of that?
I do, Your Honor. I have two witnesses that have not responded. So, but I do have other witnesses scheduled for tomorrow as well, additional to Cynthia Johnson.
Okay. When do you expect that your case in chief will be completed?
Friday.
Are you thinking Friday morning or Friday afternoon? Best you can tell today.
Best I can tell today, Friday afternoon.
Okay. And I know that Mr. Knight wishes to at least testify himself. If other witnesses he doesn't wish to call. And I know that there was, I think if my recollection, and again, I'm not trying to limit what you're planning on doing, sir. My recollection is that after Ms. Johnson and yourself, you really had nobody else scheduled at the time that the trial started.
I have nobody scheduled.
Okay?
I'm just going off of who they brought in because I know the case.
Okay. Okay, I don't need to hear more about that. And so, I suppose that there's a possibility it'll be done on Friday, but I think it's highly unlikely that we'll have the evidentiary portion done on Friday. So the other thing that I'm going to be looking to in dealing with court administration will be what would be the next potential day for us to recommence the trial. So what happens is that once we get through our block, so our block was Tuesday through Friday this week. Once we get through our block, if the parties underestimated their time, then we start looking to other opportunities, and those opportunities have to fill in my schedule. They have to fit within my schedule of other previously scheduled things. So that's what we'll be looking to do, and then what we'll end up having to do at that point is comparing what I'm available to what the parties are available for. Okay, and that's how we move forward. Okay, so what I intend to do is that when we start up tomorrow, I am going to at least be able to start the discussion of what our blocks could be, other timings could be in the near future, and then hear from everybody else, or have parties at least start looking to that, and recognize that we won't be making that decision until Friday. And on Friday, we're all going to have a better sense of where we are anyway. So, okay.
Can I make an objection?
Can you make an objection? Certainly.
I object to it going past the 4 days. This has been heard previously for 8.5 days with 27 other witnesses. They have not laid foundation for the claim to start with. We're 2 days into this trial, and they have not even touched a foundation.
So, Mr. Knight, I don't need to hear a response on that. A trial takes as long as a trial takes, okay? We rely upon the parties to provide their best guess on how long a trial will take, and then we schedule trials accordingly, okay? However, a trial doesn't stop simply because someone uses up their allotted time. Second response to that is that a party is able to present their case however they wish to present. And they may present evidence that is not, well, in all likelihood, their evidence isn't complete until the last day, until they rest, okay? And so up until that time, the court makes no decisions with regard to whether the petitioner has met its burden, and there is a burden here, and I'm sure the petitioner recognizes that they have a burden to prove by a preponderance of evidence. That that one, the petition should be granted, or two, that your request to relocate should be denied. So that is the burden they have to show. On the issue of denying your request for relocation, their case in chief isn't really even completed till after you present your case, because they are actually they're technically the respondent on that side. So, we got a ways to go before we can start even talking about people meeting the burdens at this point, so. Okay, all that being said, I think we're done for today. We'll start up again tomorrow morning.